Hello everyone, welcome back. Today we are gonna study the fourth subchapter in Contract Act, and that is legality of object. This is a key principle that determines whether a contract is enforceable or void. Let's define what we mean by the object of a contract. The object is the ultimate purpose for which the contract is made. Essentially, it's what both parties are agreeing to in the contract. The subject matter of a contract is not just any item or service, but something that must be lawful to be enforceable. So, for a contract to be legally binding, the object of that contract must be legal. The law behind the legality of object is Section 23. Section 23 of the contract law outlines the legality of the object. It clearly states that the consideration, which is what each party agrees to give or what must be lawful. If the consideration is illegal or involves unlawful actions, then the contract itself is void. In other words, if the subject matter or the purpose of the contract is prohibited by law, then that contract cannot be enforced. This could be anything from illegal activities like drug trafficking to fraud or anything that violates public policy. The next one is examples of unlawful objects in contracts. Let's take a closer look at some examples of unlawful objects that would make a contract void. So first example, A agrees to sell his house to B for rupees 10,000. Here's a simple example. But let's say A's promise is made on the condition that B will engage in illegal activities like using the house for criminal purposes. In that case, the contract is invalid because the consideration, the use of the house for illegal activities, is unlawful. So, let's go to the next example. Here, B promises to pay. Another example could be a promise to pay money for services that are themselves illegal, like hiring someone to break the law. In such a case, the contract would also be enforceable because the object of the contract is unlawful. The next topic is legal considerations. In certain cases, where the object is either fraudulently misrepresented or violates public policy, the contract cannot be enforced. For example, if two parties agree into a contract to commit fraud or mislead others, the agreement is illegal and no court will uphold it. So here, what is the term known as public policy? Public policy plays a huge role in determining whether an object is legal or not. Courts will often refuse to enforce contracts that would result in harm to society or public order, such as contracts that encourage discrimination, exploitation, or violation. Now let's see the importance of having a legal object in a contract. Every agreement which the object or consideration is unlawful. Well, without a legal object, the contract itself is considered void. This means that neither party can enforce the contract in court, even if both sides are in agreement. For example, if someone buys a stolen item, the contract to buy the stolen item is void because it involves the illegal sale of stolen goods. So to sum up, for a contract to be valid, the object must be legal. If the object is unlawful, the contract cannot be enforced and it could lead to serious legal consequences for both parties involved. It's essential that both parties ensure their contract's object is lawful before agreeing to terms. Okay, so the next subchapter is e-contracts. So, you guys think about the last time you bought something online, downloaded an app, or created an email account. You probably clicked a little box that said, I agree to the terms and conditions. What you might not realize is that you just entered into an e-contract. but all these digital agreements actually legally binding? Let's find out. So, first let's study what is an e-contract. So, simply, it's any contract that is formed, signed, and executed electronically. Instead of physical paper, we use email, websites, or software. The great thing about them is the incredible speed and efficiency. But just because they are digital doesn't mean they skip any legal steps. So, the next topic is essential elements. So, for an e-contract to be legally enforceable, it has to meet the exact same requirements as a traditional paper contract. Let's quickly break down the most important ones. So, first, there has to be a clear offer and acceptance. This is the meeting of the minds. Second, lawful consideration. Something of value must be exchanged. The next essential element is intention to create legal relations. That is, both parties must intend for this to be a serious legally binding agreement. The next one is competent parties. Everyone involved must have the legal capacity to enter into a contract. And finally, free and genuine consent. No one should be forced or deceived into signing. The next topic is role of digital signatures and examples. One of the main features of e-contracts is the use of a digital signature instead of a physical one. Laws like the Information Technology Act 2002 in India or the eSign Act in the US officially recognize these signatures as legally equivalent to a physical signature. So now let's study the types of e-contracts. So think of click wrap agreements. When you download an app and click I accept, that's a click wrap contract because you took a clear active step and it's highly enforceable. Then there are browse wrap agreements. These are the ones where a website's terms are at the bottom of the page and your continued use is recognized acceptance. These are much harder to enforce legally because there is no explicit consent. And don't forget email contracts, which are simply agreements formed through a back and forth email exchange. Let's see a simple example. So, when Anil wants to buy Microsoft Office, he goes to the website, sees the price and terms, and clicks a button that says I agree. This action shows his clear acceptance of the offer. The payment is the lawful consideration and he is now bound by the e-contract. Okay, so the next topic is advantages of e-contracts. First one is efficiency, that is faster negotiation, signing and execution. It is cost effective, that is it reduces cost associated with paper, printing and postage. Accessibility, it allows parties to enter into agreements from anywhere in the world. Fourth advantage is security. Digital signature and secure platforms provide a verifiable audit trail. And the last one is storage and searchability. Electronic documents are easy to store, organize and retrieve. Have you ever wondered if the deal you made with a teenager is actually a real legal contract or if you can be held to an agreement you signed while you were sick with a fever? Today we are diving into a crucial legal concept, that is competence to contract, and this is subchapter 6 in Indian Contract Act. Okay, so what is competence? Competence is simply legal capacity to contract. So you have the legal capacity to enter into a binding agreement. The law says you must meet three basic requirements. You must be of the age of majority, you must be of a sound mind, and you must not be disqualified by any specific law. If you're missing any of this, the contract is likely not valid. So the first one is the age of majority. A contract with a minor, that is anyone under the age of 18, is null and void from the very beginning. The legal term is void ab initio, that means from the very beginning. Why is this rule so strict? So it's to protect young people. They might not fully grasp the long-term consequences of a financial or legal agreement. The law says you can't be bound by something you don't fully understand. Okay, so the second requirement is the sound mind. This means at the time you sign the contract, you must be capable of understanding what you're doing and making a rational decision. This doesn't mean you have to be a genius. It means you just need a basic clear understanding. A person who is mentally unstable but has moments of clarity can enter a contract during those clear moments. A person who is usually perfectly fine, like you or me, cannot enter a valid contract while they are with a heavy fever or severely intoxicated, etc. So, the next topic is other disqualified persons. The third and final category is disqualified persons. These are people who, for specific legal reasons, cannot enter a contract. And the list includes alien enemy, a citizen of a country with which your nation is at war. Second one is convicts, currently serving a sentence. And even people who have been declared insolvent and are unable to pay their debts. These rules exist to uphold public policy and protect the legal system. Okay, so the next topic is the e-contract connection. Now here's the best part. These rules apply to the modern world of e-contracts just as much as they do to paper contracts. When you click I agree to terms and conditions on a website, you are legally entering a contract. But if you are a minor or if you don't have a sound mind, that click is not legally binding. The same laws protect you online. Okay, so the next topic is about consent. So have you ever felt pressured into doing something you didn't want to do? Now, imagine that happening with a contract. What makes a contract legally binding isn't just a signature. It's something called free consent. Let's find out what it means and why it's so important. So consent means agreeing upon the same thing in the same sense, and that is very, very important. That is agreeing upon the same thing in the same sense. So in legal terms, consent is when two people agree on the exact same thing in the exact same way. It's the meeting of the minds. But just because you said yes doesn't mean your consent was free. A contract is only valid if your consent wasn't caused by a list of 5 specific problems. And think of these as the enemies of free consent. So the 5 enemies or the 5 specific problems of free consent are, so the first one is coercion. This is when you're forced to agree using threats or physical force. Sign this or I will. That's a classic example of coercion. Second one is undue influence. This is more subtle. It's when someone in a position of power, like a doctor over a patient or a lawyer over a client, abuses that trust to get you to agree. And the third one is fraud. This is intentional and you lie to someone to get them to sign the contract. And the fourth one is misrepresentation. This is a false statement, but it's unintentional. You say something that you honestly believe it's true, but it turns out to be false. So the last one is mistake. This one is a bit more complex. It's when one or both parties are simply mistaken about a fundamental fact of the agreement. Okay, first one is coercion, and this comes under section 15. This means committing or threatening to commit an act forbidden by law to make someone agree. And the second one is undue influence, that comes under section 16. Using a relationship of trust to exploit someone. And next one is fraud, that means deliberately making a false statement with the intent to deceive the other party. And misrepresentation comes under section 18, that means making a false statement believing it to be true without any intent to deceive. The next topic is mistake. So a contract is not valid if it is based on a mistake. And types of mistake, there are mainly two types of mistake, that is mistake of fact and mistake of law. So under mistake of fact, again there is subclassified into two, that is bilateral mistake and unilateral mistake. Bilateral mistakes are where both parties are mistaken about a fundamental fact. And in case of unilateral mistake, only one party is mistaken. And under mistake of law, there are two, mistake of Indian law and mistake of foreign law. In case of mistake of Indian law, the contract is still valid as everyone is presumed to know the law. And in case of foreign law, it is treated as a mistake of fact. Okay, so free consent, section 13 of e-contracts. So free and genuine consent is one of the essential requirements for an enforceable e-contract. A click wrap agreement where you click the I agree option is only valid if that click was made with free consent. If a person's computer was taken over by a virus that automatically clicked I agree to a fraudulent contract, their consent was not free and the e-contract is not valid. Okay, the next topic is coercion, and it comes under section 15. So the motive is to compel another person to enter into a contract. The two forms of coercion, committing or threatening to commit any act forbidden by the Indian Penal Code. This includes physical threats, assault or threats to destroy property. And the second form of coercion involves unlawfully detaining or threatening to detain another person's property. This is often used to pressure someone into a contract to get their property back. The next topic is the effect of coercion. A contract entered into under coercion is voidable at the option of the party whose consent was coerced. The aggrieved party can choose to either cancel the contract or uphold the contract. So now let's see some powerful examples of coercion. High interest rates. Charging high interest rate is not coercion as it's not forbidden by the Indian Penal Code. Threat to commit suicide. A threat to commit suicide to compel someone into an agreement is considered coercion as suicide is a publishable act under the Indian Penal Code. So now let's see coercion and e-contracts. The same legal principles apply to digital agreements. So, for example, a person is forced under a threat of violence to digitally sign a contract using their signature authentication. The consent in this e-contract is not genuine because it was obtained through coercion. So, as a conclusion, let's say electronic signatures and paper signatures are alike, are invalid if they are not given freely. Okay, the next topic is undue influence, and that comes under section 16. It's when a person is in a position to dominate the will of another, uses that position to gain an unfair advantage in a contract. It's not about physical force but about a relationship where one party can't make a truly independent decision. So now let's see the relationships of undue influence. There is a presumption of undue influence in certain relationships where one party holds dominance. For example, parent and child. guardian and ward, doctor and patient, spiritual advisor and follower, trustee and beneficiary, lawyer and client. Okay, so the next one is the legal test for undue influence. To prove it, you must have two things. The other party was in a position to dominate their will, and the other party actually used that influence to obtain consent for the contract. So let's see the court's role. If these 2 points are proven, the court may presume undue influence and shift the burden of proof to the defendant to show the consent was in fact free. So now let's see the effect of undue influence. Like with coercion, a contract caused by undue influence is voidable at the option of the party whose consent was so caused. The court can set the contract aside and order the aggrieved party to repay any benefit they received with condition the court deems just. So let's see undue influence in the digital age. So for example, if a caregiver uses their position of trust over an elderly person to make them digitally sign a property transfer using their laptop, that e-contract is voidable due to undue influence. The law protects the vulnerable regardless of the format of the contract. The next topic is fraud, and that is under section 17. So it is an act committed by a party to contract with the intent to deceive the other. So let's see some key aspects of fraud. Silence as fraud. Generally, silence is not fraud. So let's see when silence is fraud. Silence amounts to fraud when there is a duty to speak. For example, in a fiduciary relationship like a parent-child or trustee-beneficiary, or if the silence is equivalent to speech. So let's see an example. A has a horse that is unsound and B asks if it's sound. If A says nothing, it is a lie by silence. So now let's see when silence becomes fraud. In change in circumstances. If a representation was true when made by but becomes false later and the person does not correct it. Half truth, when a person discloses only part of a fact and conceals the rest. The undisclosed part makes the disclosed part misleading. So the next one is the effect of fraud. A contract induced by fraud is voidable at the option of the party whose consent was obtained by fraud. Let's see fraud and e-contracts. So for example, if an online seller intentionally misrepresents the specifications of a product on a website to get a buyer to click I agree and purchase it, the e-contract is voidable. The buyer's consent was not free due to the fraudulent act. Okay, so the next topic is misrepresentation, and that's come under section 18. A false statement of fact made innocently without any intention to deceive is known as misrepresentation. So now let's see the difference between misrepresentation and fraud is the lack of intent to deceive. So in case of fraud, and there is an intention to deceive the other party. In case of misrepresentation, there is no intention. So now let's see the types of misrepresentation. There are 3 types. First one is unwarranted statements. That means a person makes a positive statement of fact that is not true even though they have no reliable reason to believe it. Second one is breach of duty. When a person breaches a duty of honesty, causing another person to make a mistake to their prejudice. And the third one is causing a mistake where one party, however, innocently causes the other party to make a mistake about the substance of the contract. The next topic is the effect of misrepresentation. It is voidable at the option of the party whose consent was obtained. And the aggrieved party can choose to cancel the contract and demand that any benefit be returned. So, the next topic is mistake, and it comes under section 20, 21 and 22.
So as we said, there are two types of mistake of law and mistake of fact. So under mistake of fact, there are two types: bilateral mistake and unilateral mistake. Bilateral means when both parties are under a mistake, and unilateral mistake is where one party has a mistake about a fact. Okay, with this we will conclude this video and we will continue it in our next video. Thank you and keep learning.